Recently, Supreme Court actually, I think they upheld the decision, but they gave some mercy to her, saying that you can approach the governor for mercy, because the act was done when she was only 19 years or 20 years. They said she had suffered a lot. So please approach governor. They have approached there, but we don't know what has happened so far with the governor. It is pending before the governor, but she's still out. She's not inside the jail now, because Supreme Court itself they were showing some mercy to her because of her background, well-mannered thing which she had done in the jail. When she was in the jail, she helped many convicts by drafting everything. That also became news during those days. See, in this minimum wage, you just underline the word floor wage, which is here, floor wage. Okay, and then you underline this word shall fix a minimum wage rate which is lower than the floor wage. Just underline this. What the code says is that central government can fix the floor wage below which the state government cannot fix. Okay, that is the amendment, but central government so far has not fixed the floor wage. So this is one amendment which you should be aware. And earlier in this amendment number 6, equal remuneration means only men and women. That was considered. Now under the code, it is all genders. There is a transgender act also was passed in the year 2019, as you are aware. Even they come under the purview of this act. Even they should be given equal remuneration if they are, okay, here, yeah, non-discrimination against all genders. That is the only change here. And payment of bonus, I think there is no change. As of now, it is 21,000 only. You have to await for the state rules if they are changing anything. Because we heard that PF, they are changing it to 25,000. From 15,000 to 25,000, there is some enhancement, there is some news, but it is yet to be notified. Okay, Social Security Code, I have not taken much of the amendments. Next, okay, only 2 I have taken because everything is related to wages, which I already explained with respect to ESI, gratuity. Only thing is that you can underline this word, 1 year. Fixed term employee, 1 year. And working journalist, they made it 3 years. Might not be applicable, but for your information, if they have worked for 3 years, they will be eligible for gratuity. For you and me, common men like you and me, it is 5 years only. 5 years only. No changes there. This one, they brought that under the Provident Fund Act, Mayor Code reduces the rate of contribution from 12% to 10%. It is there, but no one will implement it. It will be 12% only. Okay, just for your information. Next. Core and non-core we have already completed. Go to page number 15. Just underline this word 180. You know, right, for every 1 day of working, for every 20 days of working, 1 earned leave needs to be given. For that, the earlier law said he was supposed to work for 240 days in a year. Now that has been reduced to 180. That is one change. And also, I think carry forward was up. Wages were carry forward. If it is more than 30, leave encashment was left to the discretion of the management. It was not compulsory. Only at the time of cessation of employment, if the employee had retired or resigned or terminated, management was supposed to give leave encashment. But while in service, if there was more than 30 leaves, management had the right to forfeit it. They could have said, I will not pay. Law does not say so. Of course, many companies, they pay 45, 90. For example, Toyota pays 90 days for workmen, 105 days. That is the thing which they have brought in their settlement by way of negotiation. But the law said more than 30 days, no need of payment of leave encashment. But now the law in the code, it says more than 30 days, employer is obligated to pay leave encashment while in service also. That is the difference. Yes. Okay, that is one change. Now this is a very third-party safety audit they have brought under the code, wherein earlier only factory inspectors could have inspected. Now government says a specialist can be appointed through the government only. This was in practice in some states, but now they have brought it in the code. So you can expect some specialists to come and do the safety audit on behalf of the government instead of the factory inspectors, which is already there in the practice. And this Screech You just underline this word 30 and 50. See, before under the Factories Act it was 30, now it has been increased to 50. But anyway, maternity leave, Maternity Benefit Act, earlier also it was 50 and above. But in the Factory Act it was specifically said if there are more than 30 only, you are supposed to give creche facility, right? With respect to that, some people had confusion which one to follow. Which one to follow? See, as per the Article 244 of the Indian Constitution, it says if there is inconsistent law, central act will prevail. If the state government says one law, central government states one law, it will be central act will prevail. This is what Article 244 says. But as per some of the judgments from High Court and Supreme Court, which beneficial law will prevail? Which law is beneficial to them, you have to give. For example, in under the code, it says 30 and above, you have to give leave encashment. Okay. Whereas under the SND, it might say 45 and above, they are entitled. Which is more beneficial, you please give. There is some contradiction between the code and SND, but always go for which is more beneficial on a safer side. This has been held by the Supreme Court and High Court as well. Okay, this is for your information. And then amendment number 7. Okay, canteen also, it is just a change of numbers. Earlier 250 and above, they were supposed to give the canteen facility. Now it has been reduced to 100 and above. You just underline those two, 100 and 250. And this interstate migrant workers, earlier it was applicable only to contract laborers. Now it has been made applicable even to the employees engaged by the principal employer, subject to his wage not exceeding 18,000. So more or less it will be not applicable to them, because it will be exceeding more than 18,000 only for the principal employer. So again it remains as a compliance for contract laborer only. Okay, just underline that. 18,000 direct employees are included, 18,000. It says direct employees are included. No. Okay. No. What was the earlier law? Was it there 18,000? No, I don't think so. No. Then I don't think so. It is there for contract laborers. It is applicable for them. But for direct employees are included if their wages do not exceed 18,000. You just clear me. According to me, only for direct employees it is 18,000. Okay. But this was the interpretation which I had discussed with others. Let's see that. Increased 10 members. Anyway, that is very minute. No, most of them will have more than 10. Okay, that was the earlier law, wherein if they are staying in Bangalore, they cannot be called as interstate migrant worker. If a Chennai fellow is already staying here, if we engage them, it is not interstate migrant worker. This was the earlier law. What you are saying is that even they. Okay. So next one, safety officer. It has again the threshold has been reduced from 1,000 to 500 or more, and if it is an hazardous process, it is 250 or more workers. You have to engage one safety officer, and further we are awaiting for the state rules. Every 250 workers we need to engage one safety officer. This is what the rule, or we have to wait more than 1,000. Again, one more we have to what? Every 500. So that we need to check the state rules. Yeah. See, this strike and lockout we have already completed. So amendment number 2, time limit for completing disciplinary proceedings. can underline this word 90 days. See, it uses the word ordinarily should be completed within 90 days. For POSH Act, what is the limitation? Tell me. Within how many days we need to complete? 90 days. 90 days, right? But for domestic inquiry, for general misconducts, there was no limitation. Only there was one judgment which said it should be completed within a period of 6 months by providing all the opportunity. But it was not followed strictly. Even now it is very difficult to follow this law strictly, because we have to give them opportunity in terms of principle of natural justice. We cannot compel the inquiry officer to complete within 90 days, because once if we dismiss that said workman, he will go to court and say that domestic inquiry is held I was not given proper opportunity. In the court, the first issue that they will frame is whether domestic inquiry held is fair and proper. In case if the court holds that it is not fair and proper, you have to lead fresh evidence before the court. Judge will become like an inquiry officer there. Before him, we have to take all the witnesses. Where you will take, because by the time that order comes, it will take 3-4 years in the court. And most of your witnesses or employees who had given witness in the inquiry, they would have left the organization. So your case will become very weak there. If the if you do not give opportunity in the domestic inquiry, and later on if the court holds that it is not fair and proper, you do fresh evidence before me, you will fail to bring the witnesses before the court. So it is better to give reasonable opportunity instead of following this strictly. Okay, there are many inquiry officers. Even Umesh conducts many inquiry. Rangaswamy conducts inquiry. Yeah, next. See, RLC, Regional Labour Commissioner, RLC, retrenchment, layoff and closure. Only change is that earlier, if you wanted to lay off any person or retrench anyone, or if you want to close the establishment, if you had more than 100 workers, you are supposed to take the you are supposed to file an application before the labor department or government, appropriate government, and seek their permission. Now it has been enhanced to up to 300. If it is if you are having only 299 employees, you can intimate the government and close your establishment if you want. It is both no sir, correct. Overall, for numbers they will take overall. Yeah. See, it is very difficult to get the closure permission from the government. I remember when I was at BCP, I think Parle got the permission, but with it was a surprise even to the advocates, because there was a union unrest. That's why government took a bold decision to give the permission to close the factory. Now government has made it easier for the companies. If it is very hard for them to continue with the business, you can close the business without seeking our permission. You can just intimate us if you are having less than 300. But you have to intimate them. Okay, and of course this is one of the other reason why unions are crying, wherein they are saying 80% of the companies in India is less than 300. So government is supporting employers, but what the employers are saying, we never start the business to close. With that mindset, we never start the business to close. So we need some flexibility. Now the government has taken a bold decision by increasing the threshold from 100 to 300. For Infosys employees, if you want to retrench, are you supposed to go before the labor department to seek for retrenchment permission? Because chapter 5B was not applicable to them, if I remember. If I am not wrong, you just correct me. It is not applicable for them, because after chapter 5B, industries means factories, mines and plantation. So that flexibility still continues for you people. That's why unions are trying to bring them under the purview of ID Act, but finding it difficult. But of course, as I said in the morning, some of the software engineers are held as workmen. But if the question comes whether all software engineers are workmen, no. And salary is not a criteria to define whether he is a workman or not. Pilot was held as a workman. He was earning almost 3 lakhs. Development officer was held as a workman. So the nature of duties determines whether he is a workman or not. Yeah, that is there next. And GRC. See, if you have 20 or more, now it was there in the earlier act also, but now it's like more like a compulsory this thing now, because as per the act it says they have to first approach GRC if they have any grievance. Only then, as a second step, they can go to the labor department. Earlier they could have gone directly to the labor department. Now they have to approach the grievance redressal committee, and if they are not satisfied after 30th day, they have been given the liberty to approach the conciliation officer as a second step. So it is very important for you to form a grievance redressal committee. I think you have, right? Infosys also has the grievance redressal committee. You call it as? Okay. I hope all of you know the court, how it runs. Now the first step is GRC. Second step is conciliation officer. After 45 days, the matter can be taken directly to the labor court by the employee. Now no need of reference. Like earlier, they were supposed to make a reference through the government. It would have taken a lot of time. Now after 45 days, they will give a report wherein the employee can take that and raise the dispute before the labor court. After labor court, in case if the employee succeeds before the labor court, he can approach high court. Employer can approach the high court. Either way, whoever succeeds. In case if the workman had succeeded before the labor court, the law says section 17B was very famous among HR fraternity. Now it is section 56 of IR code. You are supposed to pay the last drawn wages to the employee who won the case in the labor court until the disposal of the case. So that rule is there. You should be aware of if you are challenging before the high court. After high court, in the high court itself there are two steps: single bench and division bench. After that, they can approach Supreme Court, SLP, special leave petition, and then one more step is there, review petition, which Darshan went and they just throwed, right? Review petition means SLP also two judges will be there, and if you are aggrieved by that, you can again approach by filing a review petition before the same judge. In the chamber only they will see, they will not come to the open court. Most of the 99% of the cases it will be thrown, just like Darshan's case. There is one more final step. This is the last one in the Indian legal system, that is curative petition. It goes before the 5 judges who sits in the chamber again. Curative petition is something wherein it is at the discretion of the judges whether they want to come and hear this matter before in the open forum and allow the advocates to argue or not. Okay, these are the steps involved. I am telling you this because we handled a retirement age case in Federal Mughal wherein our company lost and we ended up paying 60 crores because from 2012 to 2022 almost 600 employees had retired, wherein we challenged that we want 58 years as the retirement age, whereas the workers won the case and 60 years of retirement age was upheld. But since we lost the case in 2012 case, we ended up losing in 2022. During that period, 600 employees had retired. So we ended up paying 2 years arrears for all 600 employees. And we went up to curative petition. And we engaged the same advocate whom Darshan had engaged. What is his name? Very famous. Okay, next. Trade union. Okay, now this is one more thing. Trade union recognition. Earlier, trade union recognition was compulsory in 2 or 3 states. Like Maharashtra, they have a PUL Pact. Okay, it was compulsory to recognize only in Maharashtra, in Kerala, in Orissa. However, it was not compulsory in states like Karnataka. Okay, it was left to the discretion of the management to recognize the trade union or not. But now what the law has done is that compulsory recognition has been made. Okay, if there are more than 1 or 2 unions in the plant, they have said that you should form a negotiating union by giving equal opportunity for all the union. Okay, they should make like a committee. If there are 2-3 unions contesting, you have to make some. There are certain rules you can read there. Actually, that you please correct it. It's not 75%. It's 50%. You just correct this. one mistake, it's 50%. Okay, next. Yeah, Standing Order Act, again it's 100 to 300 now. Of course, for IT industry, some of the industries have got it certified. Since I saw at Bosch, BGSW, it was certified, but during the 2013 or 14, they got it certified. It is there for them, but majority of the IT industry are still running through service rules instead of standing orders. Now, that exemption is still continuing. They are not. And this is one more thing. If you approach the labor department for a standing order certification, he has to complete the proceedings within 60 days. Usually what happens, authorities will sleep over. So after 2-3 years also they would have completed. Now it says it's an automatic certification in case if you do not complete it within 60 days. This is one more thing. And penalties, I will not go through that. It has been enhanced now, penalty. And of course they have been given some opportunity to compound the offenses. Instead of going for jail, they have said that you can also compound the offenses by paying some fees. You can get it closed as a by way of if it is a first time offense. A second time offense, again that jail term everything is there, but it has been made employer friendly, but they have enhanced the fees, fines exorbitantly. Okay, next. There are certain state rules which are here. See, annual health examination was earlier it was compulsory only if they had worked in hazardous process. Now what the law has done is that if they have completed 40 years or more, 40 years or more, they should be subjected to annual health examination. That has been made compulsory now in factory, building and other construction work, BD and cigar work. Okay. And one more thing, journey allowance. This is one more coming forth in the state rules, wherein they are saying that employer shall have to pay to the interstate migrant worker in a year a lump sum amount of fare journey allowance. Have they mentioned the amount also, journey allowance? To and fro, they have to calculate something. But one more point here is, he should have worked for a minimum period of 180 days. Okay, you can underline this word. Of course, this is mostly applicable for contract workers, right? Working in the principal employer establishment also, they have to be paid. They have to pay and claim it through principal employer. No, principal employer will pay to the contractor. That's what I'm saying. But this point you just underline. There is some debate is going on here. Even is the previous employer days has to be taken into account to count this 180 days. There is some dispute, some debates are going on in the labor department. Why we should consider his days of working in the previous employment also. Why we should pay the journey. Of course, it's a peanuts. I don't think so why they are objecting it, but anyway. With respect to the record, there will be some dispute. That's what they're saying. Including the period spent with the previous employer. You can just underline this word. Okay. Next. See, this is pertaining to the working hours, which is there in the state rules, yet to be notified under the OSH and W. Working conditions on overtime wages, extra wages for overtime under section 27. Jiva, you have to interpret. For more than 9 hours in any day or for more than 48 hours in any week, working for 6 days. If you are working for 6 days in a week, if they work for 9 hours in any day, they have to be paid OT. And if they are working for more than 48 hours in any week, they have to be paid OT for 6 days working. If you are working for 5 days, up to 10 hours, first 10 hours, no need of OT, right? Up to 10 hours, no need of OT. For more than 10 hours in any day, they have to be paid OT. Okay, there is some difference between days, week. For the first time, I think they have brought, it was not there in the earlier rules. But 48 hours remains the same in a week. 48 hours remains the same. You can just underline that. See, for 4 days work debate is going on now everywhere. Some debate is going on. See, for that, the law says you have to pay OT if they work for more than 11 and a half hours in any day, working for 4 days in a week. So you can engage them for 11 and a half hours without OT. If they are working for 4 days in a week, then I think they can work up to 12 hours, right? Maximum they can work for 12 hours. It will amount to 48 hours in a week. But up to 11 and a half hours of work, if they are working for 4 days, no need to pay overtime. Earlier, anything worked over and above 9 hours, we were supposed to pay overtime. So there is some flexibility now for 4 days working also. Okay, this is one thing, and certain explanations has been given. You can go through that. Yeah, draft. It has to be notified. More or less, I think it will get notified. The same thing. Some debates are going on that also. Some important things you can underline. Okay. Okay, the last one. Just be aware of this section. Okay, section 110. This is not rules. It is under the code only. You can just underline this word, not initiate prosecution proceedings against an employer for any offense under this chapter. Give an opportunity to comply with the relevant provision of this act within a period of 30 days. If there is any non-compliance related to HR related registers, everything, the authorities cannot directly go and file a prosecution. They have to give an opportunity to the employer to correct it. And you have to correct it within 30 days. And it also says no such proceeding shall be initiated against such employer until you give an opportunity. For small things, if you had not taken care of the factory inspectors, they used to file a case, right? If you are not paying something to them. But now the law says we have made it much easy, employer friendly. If they do that, you can always go and go to the court by engaging the advocates and get it quashed. But this rule is not applicable for safety related violations. Safety related violations, they can file a prosecution. In fact, our MD was worried about because there was a lot of non-compliance in our construction. We are building one big factory in Devanalli, but there was a lot of non-compliance from the contractors there with respect to the registers. So I just showed this to him and specified him. So if you know this kind of section, you can specify and get away in the corporates. So it's always it is there at 24. This comes under OSH code. It is not there. Okay, we added today morning. Okay. Okay. I have. We'll go for test, but before that, some of the experts can answer this. I got something note. Some of the experts sitting here now can answer this. What is this? Important laws. Okay. Gender women workforce. Can someone ask this question? Gender women workforce, someone has written. No, you mean to say the percentage of workmen that they can engage with respect to. Yeah. See, with respect to wage definition is applicable the same for everyone, and minimum wages also it is applicable to them. Okay, and there are certain facilities has been brought. Yes. See, women employees can work in night shift now. There is no such thing as earlier they were supposed to take permission. I think it has been removed in Karnataka long back. Yeah. Certain rules and regulations are there. Actually, it is not there now here. Okay. We also prepared one policy recently at Carl Zeiss. If you want, you can share Aditya. Anyone wants. We have brought in all the OSH code rules into that. They have to be given transportation facilities, and at least 5 women employees needs to work in each 10. If I remember, it's 5. Okay. No, under the code it is 5 or 10. Okay, 10. And certain pause should be in place. Anyway, that will be there already. With security, CCTV. It was always there. Even earlier, there was a Madras High Court judgment which they have cut and pasted in the code. Actually, these things were. It is part and parcel of the judgment. Yeah, yeah. And mother's return, you have written. Now it is there is no law change with respect to the Maternity Benefit Act. I think the timeline is how many weeks? 20 weeks, 26 weeks only. 26 weeks only, even under the code. Of course, in your policy, they will make it more flexible. In our company, I think they can take another 6 months of sabbatical, all those stuff. It is there. It is a company-driven policy, over and above. And also, our company have taken a call that we will not reduce the wages, maternity benefit wages. Now we can pay on the wage definition. Earlier we were paying on the gross wages. We are continuing that. We are not reducing that benefit in our company. It depends on the company to company. But if required, they can reduce it from gross wages to wage definition. Wage definition. Now who will say? Who can question? We are doing it in terms of law. You are telling it's a service condition. No? Yeah, that's what. Okay. Anyway, I think most of the companies they will not reduce it. If I am wrong. Correct, sir. Santosh Rao, sir. Even Toyota they are not reducing it. They are paying. Okay. And then children provision, child care provision, we saw that creche facility, it has to be given. And also I think tie-up is allowed outside the organization, which it should be reasonably within 500 meters, something is there in the Karnataka rules. But it is strictly not followed. We are also having tie-up, but they are far away from 500 meters also. I think we have intimated the factory department also on that. They are okay with that. They have given some acknowledgement. So on a safer side, you take that, because some of the auditors they will come and question. We will not have any problem with the labor authorities. These internal auditors, no, they will come with a checklist, lot of 1,000 compliances. They have to show their presence. That's why we always use that formula. Either we have to convince or confuse. Even in the BCP also taught us the same thing while I was practicing. Even in the before the these auditors also we do the same thing, right? Paul, Aditya, they are all very good in doing that. And then employees with disabilities, persons with disabilities act. I think most of the companies will have this policy, disabilities provisions. Recently I have not gone through that. If someone is very expert in this, can answer this. Rao sir or Madhukar Bhatt sir, Disabilities Act. It says that it is not compulsory to engage a disabled person, right? But we should not do the discrimination. This is what my understanding. There is no such kind of reservation for them. Diversity related bias. We said no, even in equal remuneration they have brought in all genders, not only men and women. That act was always there, Gender Diversity Act 2019. Now they have brought it under the code also. What is it? Nothing is there. Yeah, Transgenders Act. Again, it says you should not discriminate them. It is not compulsory to engage transgender. We should not discriminate. If he is eligible, we have to take them. They not made it compulsory. Just like even Kannada Sarojini Maheshi report, everything is there. No? It is something like that. Even for women employees, we had a recent amendment. Now, what is that? Special leave for them. It is menstrual leave. Menstrual leave. That is also not compulsory. We have not implemented it in our company. Maybe Infosys might have implemented. I don't know. Because it is in the nature of office order, we are saying, and it has also it has been challenged before the court. If it is not implementable, I don't know why they have challenged it in the first place. This is my, yeah. If it is not implementable, why we want to go to the court and seek for stay of that? This. Okay, it was only on the basis of request. That's it. They cannot compel. Maybe IT industries can implement it because most of you can work from home, but for manufacturing setup it will be very difficult, so we have not implemented it as such. It is against the yeah. Ball, you get ready with the test. It's So shall we go for test now? So 1 lakh is at stake. Top 3 will get 1 lakh. Okay, 1 lakh worth of prize from Carl Zeiss. All of you can go for it. Anyone in this room? All of you take your mobile. Okay. whatever you have studied in your college, it is just a one piece of it. But the real learning starts once you start working. So just keep that triple L. Just be in that zone, triple L. Maybe you're reading a book, it will be of a great help. The second one is triple C. Always try to be cool, calm, and composed. Okay. For that, you need to, maybe you can go for Art of Living, Sudarshan Kriya, or Isha Foundation, Inner Engineering. And there is one more concept called Kriya Yoga, which is there in Jharkhand. And Rajnikant and Virat Kohli will follow them. That is a Kriya Yoga, which they have said that it is of a great help. So because if I say it to do, you will not do. If I say Rajnikant or Virat Kohli as you are doing, people will do. That's why I'm telling that. And the third one is do not suffer from LKK syndrome. Anyone know what is LKK? It's a Hindi word. Log kya kahenge syndrome. So never suffer with that. Okay, just be bold enough. Say whatever you want. Do not hesitate. And the last one is very important for HR. Be sensible and be sensitive. Okay, because you people have the weapon to terminate or dismiss someone. But that do not forget the sensitivity part. Okay, because they only have to pay the fees for their children. Okay, so do not forget this double S. Be sensible and sensitivity should be part of your life. And one pro tip, is it ready? Okay, then we'll start with the test. Can you all open up your mobile? Everyone in? Anyone having trouble? Shall we start? 20? Ready? Ready? Anyone still? Wait. So this is Indian Premier Labor Law League. Top 3 will get 1 lakh worth of prize each. I want to create the pressure. I want everyone to be under pressure, and the one with the intelligence will not win the race. The one with the intelligence plus speed. So don't try to copy. By the time you are wasting your time to copy, you will be the loser. Because Infosys people are sitting very close, that's why I'm telling. Shall we start? Anyone still? Wait. Still two people, no? Still waiting? Okay. See, every question there will be 20 seconds time. So within that you have to wait. Bala. HBK is still HBK was you're there, right? Inside? No. Okay, start. Remember the story D for dog, long walk, what is the answer? And you are answering. Okay, one person was not mentally present when the story was done. Okay, next. Rashmi, raise your hand. Okay, next. C for cat. After retirement, you will play with the cat. What is the answer? Don't answer. Okay, few of them got confused with retaining allowance. Okay. I for India, Indian movie. Kamala Hassan, what is the answer? Don't answer. I'm just helping you. So Sangeeta is leading. Let's see. You have to come in the top 3. This is just to test your focus. I said something with respect to mother of all amendments. Let me see how many were mentally present during my session. This is just to test your focus. There is no right or wrong answer. See, almost 13 people were not mentally present. Okay. It is included. What is included among these 3? Floor bracket number 1. What was there? Rakesh is leading, Jiva is leading, Mona. Very easy one. Just now we discussed. Okay, who is Rakesh? Who is Jiva? Mona. Mona, who is Grievance Redressal Committee? What is the limitation period? It's 1 year. See, there was one Me Too movement, right, in 2020 or something. Me Too, Me Too. This Mallika Sharawat had acted in one murder movie. Okay, the same was remaked in Kannada. I don't know how many of you remember Sanjana Gandhi. She came up before the social media alleging harassment during the shooting, which happened in 2015. So 2005 in 2020. So such kind of cases you cannot encourage in GRC. It has to be within 1 year. Any grievances, even under the POSH, it is within 3 months or 3+3 within 6 months. So like Me Too, you cannot encourage. They cannot come after 15 years or something. Under GRC it is 1 year. Under POSH it is 3+3 6 months. Yes. Okay. KVB, you're nearby. You can try. Okay, KVB and Leka are nearby. Last question. Huh? You know, as I said, this is not compulsory. In terms of principle of natural justice, we have to give sufficient opportunity. Yeah. So last question. ESTD means establishment. Jiva, come. KVB. And Rakesh. Sir, Madhukar Bhatt sir and Rao sir, you can come and hand over. Yeah. Actually, this Bill Gates and Warren Buffett has said books are priceless. So we just gave it a price of 1 lakh to make you people more curious and be present. As I said, I wanted your presence, not your time. Okay? Rao sir. KVB, anyone can. There is no 1, 2, 3. Top 3 will get one book. Okay, I will end by giving one pro tip. Okay, 3 pro tips I'll give for life. If you want to successfully come out in the interview process, okay, just one liner. If you want to pass any interview, always remember that interviewer would like to hire a person with whom they would like to go for a coffee or a drink. Don't forget this. Okay. What I mean to say is that don't go with a whiskey bottle or a smoke. You just give that vibe in the eyes, confidence, what you speak. Even though I don't know anything, I just give the confidence and they will hire me. This is my experience. This is back tested also. I gave this formula to some people. Back tested means some of you who will invest in F&O, they will know, or share market, they will say back tested. So this formula is also back tested. Second one, after joining the organization, many people will have problem with their boss on how to survive. Okay, I will give a pro tip. Always try to be like a soda. Soda can mix both in water as well as whiskey. Some of your bosses will be like whiskey, and some of your bosses will be like water. But if you are like soda can mix with both. So I'm always tried to be like that. So this is a one-liner formula for many, and this is also back-tested. One of my colleague had a lot of trouble with their boss. I just gave this formula, and they said, I'm feeling better. I'm trying to be like a soda. Okay? And the last one, it's a very important for those who are in IR, industrial relations, negotiation. The pro tip is, just now I said, it is worth 1 lakh. Though I gave a book, I said it is priceless. This is how we negotiate with the union. We give something like book and say this is priceless, this is like worth 1 lakh, and these are the strategies that our people will do. Pallavi, Paul and Aditya, you can just connect with them if you want. They prepare these kind of strategies on how to project it. Even though value is much less, we will always try to project it in a big way, and I made you all be present because of that, right? This is how we do even the union negotiation. We do these kind of strategies. Okay, thank you, all the best.
Thank you so much, sir, for delivering such an engaging session. Although I think we lost out a little bit in the beginning because of the technical glitch. But all in all, I think it was a great session. All of us have learned a lot. Your lucid explanation of the evolving legal framework, coupled with practical illustrations like the last test, experiential learning and real-world perspectives, coupled with a dash of humor in between, has enabled us to better appreciate the significance and implications of these transformative reforms. Thank you once again, sir. So now we are breaking for lunch. It has been served in the ground floor, the canteen area. Our faculty members are there to guide you. So please help yourselves with the lunch. And we are perfectly on time actually. So we expect to start the next session at 2 o'clock. So please reassemble here by 2 o'clock. Thank you.